I'm sorry, guys. I apologize for how this has unfolded thus far, and I want people to know that they can trust me and that I'll always take care of the fans and people who support me. And lastly, thank you, Coffeezilla. You have catalyzed this, and I am very grateful for your work and your investigation.
Before we get into it, ask yourself this. Have you ever seen someone try so hard to silence their critics that they end up making themselves look even more guilty? That's exactly what's happening with Logan Paul right now. This lawsuit was supposed to be his big comeback, the "I've moved on" era. But instead of clearing his name, it's turned into one of the most uncomfortable moments of his entire career.
Logan Paul filed this motion to preserve confidentiality so that he can mark his entire deposition as confidential. This would effectively mean that Coffeezilla can't share this deposition or any of the contents within it with anyone outside his legal team, and he could only use it for purposes of litigating this defamation lawsuit. For starters, this kind of a request to mark the entire deposition as confidential is not normal. As a root problem, he doesn't make any argument that anything in the deposition is sensitive or private in nature. In other words, he doesn't really make any real arguments as to why this entire deposition should be treated as confidential.
And get this, there's no new scandal, no leaked messages, no shady backroom deal. The chaos this time is all because Logan Paul is desperately fighting to keep his own sworn deposition hidden from the public. When someone with that much money and influence works this hard to keep something secret, you have to wonder, what's really in there?
What has been the most visceral or violent reaction to what you've done and exposed?
It's probably the Logan Paul story, the CryptoZoo saga. That was a case where, it's just the classic influencer greed story where this guy launches an NFT project, does millions upon millions of dollars in sales, and delivers nothing.
This all traces back to Logan's defamation lawsuit against Coffeezilla. Logan seemed convinced that legal threats would shut down the criticism. File a case, apply pressure, and boom, the noise disappears. But that plan completely backfired. Instead of silencing anyone, the lawsuit forced Logan into a deposition, a legal grilling under oath, and now he wants that testimony completely sealed. Not redacted, not trimmed, fully hidden.
He addresses Logan Paul's argument that Coffeezilla failed to essentially try to work things out with him before resorting to the official objection process here. Like I said in my last video, if it's clear early on that going back and forth in the meet and confer process is just going to be a total waste of time, Coffeezilla isn't required to keep engaging with Logan Paul. And here, Coffeezilla says trying to meet and confer with Paul was totally futile because Paul made this blanket designation of confidentiality over the entire deposition. And Coffeezilla throws some shade here when he says, by filing his motion without conferring with Coffeezilla, Paul incontestably signaled his desire simply to suppress anything depicting him in a less than flattering, i.e. not self-produced.
Every question, every answer, locked away from the world. Normally, if someone asks for a deposition to be sealed, they give specific reasons, like personal medical info or private family matters. But Logan didn't do that. Not one reason, no details, no page numbers, nothing. His lawyers argued it's not about what he said, but who might hear it. They claim Coffeezilla can't be trusted, that he might leak it, share it with investigators, or hand it off to other lawyers. But here's the thing, none of that is illegal. There's no law saying discovery materials must stay secret forever, no rule that stops someone from sharing lawfully obtained information with the authorities, and absolutely nothing banning someone from reporting potential wrongdoing. So when you strip away the excuses, what's left? Fear. Because feeling embarrassed isn't a legal argument, feeling exposed isn't a legal argument, and regretting what you said under oath definitely isn't one either. Coffeezilla's legal team made it clear. Unless the deposition includes truly private or sensitive info, there's no reason to hide it. If Logan contradicted himself, dodged questions, or admitted things that hurt his own case, that's the entire point of a deposition. It tests honesty and consistency under pressure. But Logan isn't saying he's protecting anyone else. He's saying the deposition is dangerous because of what it reveals about him. That's not privacy. That's damage control. If Logan had performed well under oath, you'd already be seeing clips all over YouTube. He'd be shouting, "See, I told you." But instead, he's begging the court to keep it secret. And that silence says everything.
He promises the world a fun blockchain game that earns you money, and he did nothing, and the project was left abandoned, and people were like miserable, complaining. No one says it, but
I'm not
they
aware
don't have a
of that.
voice.
Depositions aren't YouTube videos. No editing, no jump cuts, no charisma saves. You sit, you answer, and your words are frozen on the record. If that transcript ever goes public, it'll show exactly what he said. No filters, no spin, just truth on paper. That's why his push for secrecy looks less like protection and more like panic.
Now, here's where it gets wild. Logan's team claims Coffeezilla has been sharing lawsuit info with the FBI, and because of that, Logan argues Coffeezilla can't be trusted with the deposition transcript. Think about that. He's saying that if someone shares potential evidence with investigators, they should lose access to court materials. That's not how the system works. Unless a judge issues a specific protective order, there's nothing illegal about reporting possible fraud or misconduct. In fact, it's the responsible thing to do. Coffeezilla's team hit back hard. They explained that if discovery reveals wrongdoing, alerting law enforcement isn't wrong. It's in the public interest. And here's where Logan's logic collapses, because his own legal team reportedly contacted the FBI using the same type of materials. So it's okay when he does it, but not when Coffeezilla does it? That double standard doesn't hold up.
Anyway, Coffeezilla then addresses Paul's next argument, the one where Paul complains about Coffeezilla sharing information with the FBI and with the CryptoZoo class action plaintiffs. And then Coffeezilla says, regardless, disclosing information to the FBI is a lawful use of discovery materials and is not prohibited by the protective orders. Coffeezilla essentially says, hey, pot calling the kettle black much? Logan Paul's lawyer sent a detailed letter on December 1st, 2025 to the FBI, making his own accusations against Coffeezilla and explicitly referring to material he obtained in discovery in the case, including emails and phone calls.
Logan's next defense was the so-called protective order. He claims Coffeezilla violated it by sharing lawsuit info. But when you actually read the order, it doesn't say what Logan's implying. A protective order isn't a gag order. It's not meant to hide uncomfortable facts. It's there to protect genuinely private or sensitive info, like personal data or unrelated third parties. And once again, Logan hasn't identified a single section of his deposition that fits that definition. Instead, his request is a blanket seal everything. But courts don't operate on fear or feelings. They operate on facts and evidence. Logan also complained that Coffeezilla shared discovery materials with the CryptoZoo class action lawyers. He framed it like some kind of betrayal, but when two cases involve the same project and overlapping people, sharing non-confidential info is completely normal. It's common practice, not conspiracy. Much of what Logan's upset about was already public. Court filings, official documents, stuff anyone could access. So the idea that Coffeezilla leaked anything just doesn't hold up.
Looking at this list of categories for protection and looking at how in his motion Logan Paul doesn't claim that any of the information triggers any kind of privacy right, whether that's his or some third party. Like, again, unless I'm missing something really important here that, it happens as much as I hate when it does, I don't see anything in this motion that tells me, yeah, there's some reason to keep this confidential. So at the end of the day, I'm thinking this is pretty likely that it's going to be denied and that the deposition is likely to get shared. And I'll just say, if this deposition does find its way to the internet, I, for one, would be very interested in watching.
At this point, it's clear. Logan isn't protecting sensitive data. He's trying to stall momentum before it snowballs. Because if that deposition helps other lawsuits or shows contradictions between what he said publicly and under oath, the whole story unravels. And you can hear it in the tone of his arguments. The confidence fades, replaced with strain and desperation. Nobody fights this hard to hide something harmless. This isn't about defamation anymore, it's about containment. If the deposition becomes public, it could affect every CryptoZoo case, reshape public opinion, and tear down years of image building.
Nothing in the protective order that restricts the use or disclosure of non-confidential information. And so here's where I think Coffeezilla lays down some strong hints as to what it is that Logan Paul is so afraid of getting out from his deposition. Here, Coffeezilla says, the mere fact that Paul comes off poorly in his deposition is no basis to keep the entire transcript confidential. If, for example, Paul was evasive during his deposition or admitted to making misrepresentations, which would support Coffeezilla's defense of truth, of course, that is no basis to keep his deposition hidden from the public. And if Paul's testimony contains evidence that a crime has been committed, not only will that testimony not be confidential under either the protective order or any common law definition of confidential, but it would be contrary to the public interest to shield it from law enforcement. So, response to Paul's argument about sharing information with the CryptoZoo class action plaintiffs as well. Specifically, he says, Paul also suggests Coffeezilla is improperly sharing confidential information with counsel in the class action, citing a YouTube video in which class action plaintiffs counsel claims Paul's defamation case was helpful to the class action case. Paul omitted from his motion what class action counsel found.
But Logan's weakest argument yet is that Coffeezilla hasn't shown an urgent need for the deposition to be public. In his view, if no one needs it right now, it should stay sealed forever. That's not how transparency works. The burden isn't on Coffeezilla, it's on Logan. He's the one who has to prove why this deposition should be sealed, and he hasn't. Not one page, not one sentence. His argument isn't legal, it's emotional. It's pure damage control. Legal experts reviewing the filings agree. None of this meets the standard for sealing testimony. Courts don't hide evidence because it's embarrassing. They don't protect reputations at the cost of accountability. And here's the irony. While Logan's begging the court to seal everything, he's still talking about the lawsuit publicly on YouTube. He's defending himself to millions while asking the judge to hide the real evidence. That's like trying to close the curtains while shouting through a megaphone. It gets worse. Logan's already admitted fault in the past. He once thanked Coffeezilla for exposing issues with CryptoZoo, promised refunds, and said victims would be paid back. But if his deposition doesn't match those promises, the fallout will be brutal. Because years have passed and many people still say they haven't seen a single refund. Coffeezilla didn't sue Logan out of nowhere. He kept following up, asking where are the refunds, holding Logan to the very words he said publicly. And instead of making things right, he chose to sue the person who wouldn't stop asking questions. That single move led to this deposition, the same one he's now trying to bury. And that's what Logan Paul is fighting to keep hidden.
A deposition isn't a vlog. There's no editing, no jump cuts, and no charm to save you. Just questions, answers, and truth on record. If that transcript ever goes public, there'll be no spin, no filters, and no escape. Just Logan Paul's words exactly as they were said. He could have paid people back. He could have owned it. But instead, he delayed, denied, and tried to bury the story. Now that same story is coming for him. If the court denies Logan's request and the deposition finally becomes public, there won't be any edits or clever framing, just the truth in his own words. Let me know what you think in the comments, and if you want more deep dives into influencer lawsuits, accountability, and what really happens when internet fame collides with real-world consequences, hit that like button, subscribe to Online Fallout, and share this video with someone who needs to see it. See you in the next one.